welcome to the deep dive. Today we're tackling a big topic, criminal responsibility and defenses. We've got a lot of dense legal material, and we're going to distill it into a really structured, element-by-element framework you can actually use.
Exactly. Our goal isn't just definitions. We want to build that fundamental architecture for analyzing defenses, really modeling how courts think. It's crucial to get the distinction right. When does a defense wipe out the crime itself versus when does it just, excuse the person?
That structure is definitely key. So the specific problem we're zeroing in on is twofold. First, how do we even categorize all the possible criminal defenses out there in a logical way? And second, how does that structure help us understand a really tricky area, intoxication, especially how it affects proving criminal intent, which often gets tangled up in policy?
Okay, so here's the plan. We'll start with the classification system, Professor Paul Robinson's 5 categories to get everything organized. Then we'll use a very structured method, think FIRAC, elemental analysis on the basic concept, failure of proof, and then we'll apply that same rigorous method to voluntary intoxication, looking at the constitutional side through a big Supreme Court case, Montana v. Egelhoff.
Okay, let's start with that structure. What are the 5 main categories of defenses? And maybe, more importantly, what's the real conceptual difference between a justification and an excuse? They sound similar.
They do, but they're fundamentally different. The 5 categories are failure of proof, offense modification, justifications, excuses, and non-exculpatory defenses. But yeah, the key split is between justification and excuse.
Okay.
A justification is all about the act. The conduct might look criminal on its face, but in the specific situations, society actually sees the act as acceptable, maybe even good, because it prevents a worse harm.
Like the classic example.
Right. Burning a field to create a fire break to stop a wildfire. Technically arson, but the act itself was justified.
Got it. So what about excuse?
An excuse, on the other hand, focuses on the actor. The act itself was wrong, harm occurred, but we decide not to hold the person responsible. Why? Because of some condition they had, like legal insanity, or maybe they acted under duress, or they were too young, like infancy.
Ah, so the blame shifts.
Exactly. It shifts from the person to the excusing condition. So justified acts are seen as okay, while excused actors are seen as not blameworthy, even though the act was wrong.
Acts versus actor. That makes perfect sense.
Yeah.
Okay, let's test drive the first category then, failure of proof. You said this isn't really a defense in the traditional sense.
Well, yeah, it's more accurate to say the prosecution just failed to prove every element of the crime they charge. It's the most common way people are acquitted.
Let's use that classic umbrella scenario. A man takes an umbrella, he honestly thinks it's his. Let's analyze this using our structured method. First, what are the legally dispositive facts?
Okay, facts. The defendant definitely took an umbrella. He picked it up, carried it away, and crucially, that umbrella actually belonged to someone else. But his belief was absolutely sincere. He genuinely thought it was his own. It was just a mistake.
And what's the core legal issue that mistake creates?
The issue is pretty direct. Does that mistaken belief cancel out the specific mental state, the mens rea, that the crime of larceny requires?
Right. So what rule of law applies here? State the full rule, and let's break it down into its elements.
Okay, this falls under failure of proof because his claim directly attacks an element of the crime. For larceny, the rule generally requires proving the defendant intended to steal property of another. So the rule really has 2 core elements the prosecution must prove.
Which are?
1, the defendant did the physical act, the taking and carrying away, the actus reus. And 2, the prosecution proved beyond a reasonable doubt that he had the required mental state, the mens rea specifically, the intent to steal property he knew belonged to someone else.
Thank you. Now for the court's elemental analysis. Let's walk through this element by element. How did the court handle the first element? The defendant performed the physical act.
That one's easy. The court finds, yes, he clearly performed the physical act. He picked it up, he walked off with it. The actus reus element is met, no question.
Understood. Now, the critical part. The second element, intent to steal property of another. How does the mistake affect that?
Right. So the sub-issue for this element is, did the defendant, because of his mistake, actually possess that specific intent to steal another's property? The rule defines theft as intending to deprive another person of their property.
Okay.
Since he thought the umbrella was his own, it's logically impossible for him to have formed the intent to steal it from another. That specific mental state required by the law just wasn't there. His belief, even though mistaken, negates that element.
So after analyzing both elements, what was the court's final conclusion?
Acquittal. The prosecution couldn't prove the required mental element. because the mistake of fact wiped out the mens rea. The crime of larceny, as defined by the law, was never fully committed. The burden of proof wasn't met.
Okay, that clearly illustrates failure of proof. Now let's wade into murkier waters. Voluntary intoxication. This one seems complicated. When can someone actually use the fact that they were drunk as a defense?
Yeah, it is complicated, and policies vary. But generally, voluntary intoxication works as a defense only if it operates as a failure of proof, meaning the intoxication was so severe that it actually prevented the defendant from forming a required mental element of the crime.
Usually specific intent.
Usually specific intent, yes, or sometimes knowledge. It has to genuinely negate the mens rea. It's not an excuse like, oh, I was drunk, forgive me. It's arguing, I was so intoxicated I could not have formed the specific intent the law requires for this particular crime.
Right. And this is where legislatures and courts sometimes clash because, public safety concerns are huge. Let's dig into the constitutional angle with that Supreme Court case, Montana v. Egelhoff. This case sets limits on whether states can just ban this kind of evidence. First, what are the key facts?
All right, Egelhoff, facts. The defendant, Egelhoff, was charged with deliberate homicide, basically, murder. He was extremely intoxicated around the time of the killings. Now, evidence about his intoxication, like his lack of coordination, was allowed in.
Right.
But crucially, the judge told the jury, following a specific Montana law, that they absolutely could not consider his intoxication when deciding if he acted knowingly or purposefully, the mental states required for deliberate homicide in Montana.
So the state basically said you can hear he was drunk, but you can't use that fact to decide if he had the required criminal mind. What was the core legal issue for the Supreme Court?
The big question was, did that Montana statute violate Egelhoff's 14th Amendment due process rights? Specifically, his right to present a meaningful defense by preventing him from using relevant evidence, his intoxication, to argue he didn't have the required mens rea.
Okay. What rule of law did the plurality, the controlling group of justices, apply to decide this? Can you state the rule and its elements?
Sure. The plurality didn't find an absolute right to present all relevant evidence. They said excluding evidence only violates due process if the rule offends some principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental.
A high bar.
A very high bar. So the elements we need to analyze based on their approach are roughly: one is the right to use this specific type of evidence intoxication to negate mens rea, a fundamental principle based on history and tradition. And two, does excluding it improperly stop the defendant from challenging the prosecution's need to prove every element, including mens rea?
Got it. Now for the court's elemental analysis, let's take the first element. Is the right to use this evidence fundamental? How did the plurality analyze that?
They went straight to legal history. They pointed out that early common law in England and America was actually really harsh on drunkenness.
Yes.
It was often seen as making the crime worse, not better. This idea of allowing intoxication evidence to negate mens rea.
Yes.
They found it was a much more recent development, relatively speaking, and certainly not uniformly accepted across all jurisdictions historically, or even then. It hadn't been around long enough or consistently enough to be considered fundamental in the constitutional sense. So element one fails.
Okay, so not fundamental historically. Now, what about the other angle, the core due process argument? The idea that blocking this evidence makes it impossible for the defendant to fight the prosecution's claim about his mental state. This was the dissent's main point.
Right.
How did the court deal with the second element? Does the exclusion improperly lighten the prosecution's burden?
Right. The dissenters were really focused on this. They argued, look, if the state has to prove knowingly or purposefully, preventing the defendant from showing evidence that he didn't know or act purposefully because he was blackout drunk, well, that essentially rigs the game. It's like saying the state doesn't really have to prove its case.
Makes sense. How did the plurality get around that? Especially the swing vote.
This is where Justice Ginsburg's concurrence, the swing vote, was key. She took a different tack. She argued the Montana statute wasn't really a rule about evidence blocking facts from the jury. Instead, she saw it as the Montana legislature essentially redefining the mental state, mens rea, for deliberate homicide.
Wait, redefining it. How?
Basically, the legislature was saying, for the purposes of this crime, the mental state of knowingly or purposefully can be met even if the person is voluntarily intoxicated. They effectively wrote the mens rea element in a way that made voluntary intoxication legally irrelevant to whether it was satisfied.
So the state can just define knowingly to include someone who was too drunk to actually know anything.
According to the Egelhoff plurality, yes, within limits. The sub-role they effectively established was that a state legislature can decide, as a matter of policy, that a person who voluntarily gets drunk is just as culpable, just as responsible for their actions as a sober person. By defining the mens rea that way, they sidestepped the argument that they were unfairly lowering the prosecution's burden of proof through an evidence rule.
Wow. Okay, so after that analysis, what was the court's final conclusion?
The conclusion was that the Montana statute was constitutional. Montana was allowed to prevent the jury from considering voluntary intoxication evidence when determining the mens rea of knowingly or purposefully. The state's power to define the elements of its own crimes won out.
That really highlights how policy considerations can shape the limits of even a failure of proof defense. Okay, now this gets really interesting. We've seen intoxication might negate specific intent, maybe, but what about crimes that only require recklessness? Let's use a visceral hypothetical. Imagine someone drinks a huge amount, gets blackout drunk. They then drive 100 miles per hour through a clearly marked school zone right when school is letting out, and they hit and kill someone. They were so drunk they were subjectively unaware of the risk they were creating. Can they argue their voluntary intoxication negated the mens rea of recklessness, the conscious disregard of a substantial risk?
Almost certainly no. The model penal code approach, which most states follow here, is very clear on this. The rule is, when recklessness is the required mental state for an element of an offense, if the actor is unaware of a risk only because they were voluntarily intoxicated,
Yes.
then their unawareness is immaterial. It doesn't count.
Why not? What's the reasoning?
The policy rationale is basically this. The act of getting blindingly drunk voluntarily is itself seen as reckless. Society assumes people know that getting very drunk can lead to dangerous behavior you wouldn't normally engage in. So the law essentially equates the recklessness of choosing to get that drunk with the recklessness required for the crime committed while drunk.
So it substitutes the awareness.
Kind of. It judges the defendant based on the awareness of the risk they would have had if they had been sober. You can't use the very condition you recklessly created, intoxication, to excuse their reckless act that followed.
That's a critical distinction. Voluntary intoxication might negate intent, but generally not recklessness. Okay, let's quickly touch on a classic excuse defense, now shifting focus from the act back to the actor. What about infancy at common law? How did that work?
Infancy is a perfect example of an excuse. It's not saying the act was okay, it's saying the actor isn't blameworthy due to their developmental stage, their lack of understanding of consequences.
Right.
The old common law had these really rigid tiers.
What were they?
A child under the age of 7. Conclusively presumed incapable of committing a crime, no argument allowed. Done.
Right.
Then, anyone 14 or older was treated basically as an adult, fully responsible.
I'm the tricky part.
The tricky part was between 7 and 14. There was a rebuttable presumption of incapacity. The child was presumed incapable, but the prosecution could try to overcome that.
How? What did they have to show?
They had to present evidence showing the child had sort of sufficient discretion or mischievous discretion. Basically proof that the child knew what they were doing was wrong. Things like showing cunning, planning the act, or especially trying to hide the crime afterwards, like hiding a body, could be used to rebut the presumption and show the child was mature enough to be held responsible.
Understood. Okay, we've covered a lot of ground. We've mapped out the basic structure of defense's justification versus excuse. We've rigorously analyzed failure of proof, using the mistake example, and we've wrestled with the complexities and constitutional limits of the voluntary intoxication defense, including Egelhoff and the recklessness distinction.
Right. And if we want to pull this all together into something really practical for you, the listener, when you're facing a complex fact pattern, maybe for an exam or just analyzing a case, here's a kind of diagnostic checklist, a way to structure your thinking.
Okay, let's hear it.
Step 1. Identify the legal category. Is the defense about the act itself, justification, or about the actor's condition, excuse? That frames your whole analysis.
Good starting point.
Step 2. Pinpoint the mens rea. What exact mental state does the specific crime require? Intent, knowledge, recklessness, negligence. You have to know the target element.
Makes sense.
Step 3, failure of proof check. Could the facts, like intoxication or a mistake, plausibly negate that required mental element? If it knocks out specific intent or knowledge, the prosecution likely hasn't proven the crime. Remember Egelhoff's limits, though.
Right.
Step 4, recklessness check. If the crime only requires recklessness, remember that voluntary intoxication generally doesn't work as a defense. The law usually holds the person responsible based on the risk they would have seen if sober.
That's a really useful, practical framework. Thank you.
Yeah.
So here's a final thought to leave you with, building on that Egelhoff analysis.
Right.
We saw the Supreme Court allowed Montana to essentially redefine mens rea and humor to make voluntary intoxication irrelevant, partly because the intoxication was the defendant's own choice. But what if the condition wasn't so voluntary? Could there be a state, like maybe permanent, settled insanity, caused by decades of chronic, perhaps initially voluntary but now involuntary, alcoholism? Could such a condition become so profound and fixed that the state must constitutionally allow it as a defense, perhaps as insanity, even if it originated from addiction? Where does the law draw that line between voluntary risky behavior and a truly disabling condition beyond the actor's control?